from our Johannesburg studios. Hello and welcome. My name is Zoleka Kotashe. Thank you so much for joining us as we reflect on the year that was for South Africa's justice system. Justice was under scrutiny on the 6th of July when KwaZulu-Natal Police Commissioner Nhlanhla Mkhwanazi made bombshell allegations of infiltration and political interference in the criminal justice system. But it was the details that followed that equally stunned South Africans.
And that is a strategy that the criminals employ, that everyone has a price. If you cannot bribe an arresting officer in blue uniform on the street, then definitely must bribe the detectives who carries a docket. If you're not successful in bribing a detective that carries a docket, you must bribe the prosecutor that prosecutes your case. If you're not able to bribe that prosecutor to prosecute your case, you must bribe a presiding officer. If you're not successful with that presiding officer, then you must bribe a correctional service official. There's a value chain of the justice system. In one way or another, there's weakness in the chain.
One name that rang loud at the heart of the allegations of capture of the criminal justice system, one Vusimuzi Cat Matlala.
Well, in 2000, you were arrested for possession of suspected stolen property. The matter was withdrawn, you'll recall.
In 2000?
Yes.
That's a long time, yes, but I will say yes, yeah.
Yes. Also in 2000, in Silverton, you were arrested for theft out of a motor vehicle. That too was withdrawn. You recall?
I don't recall, but I take it.
Okay. Also in 2000, you were again theft of a motor vehicle in Brooklyn. That too was withdrawn. You recall?
Yes.
And in 2001, in Cinderville, you were arrested for burglary at a residential premises. In fact, you were convicted of that. Is that correct?
Yes.
And what kind of sentence did you get?
4 years.
You served it?
Yes.
2006, cash in transit, acquitted.
Yes.
2011, theft of a motor vehicle, it was withdrawn.
Yes.
2012, house robbery, possession of suspected stolen goods, withdrawn.
Yes.
2012, Brooklyn, common assault, withdrawn.
Yes.
2012 in Mamelodi, possession of housebreaking equipment, withdrawn.
Yes.
2013 in Alberton, house robbery, withdrawn.
Yes.
2015, Silverton, carjacking and possession of suspected stolen goods, withdrawn.
Yes.
2016, possession of a firearm without a license, impersonation of a police officer, resisting and obstructing or assaulting a police officer, withdrawn.
Yes.
2018, attempted murder, withdrawn.
Yes.
South Africa's bail regime came under fire after a senior judge is accused of receiving a bribe to grant bail.
He had already received information from informers and sources to say, Kadisomli, if you will get bail. They went as far as giving the figures as to how much he's going to pay for his way.
And while one judicial officer denies taking bribes, another stands accused of accepting them for favorable court outcomes.
That I consider the charges against me as the result of a personal vendetta conducted against me by parties who were involved in a civil dispute with each other relating to the succession battle within a church group called the International Pentecost Holiness Church, the IPHC, after the death of the then leader of the church, one Bishop Leighton Modise.
Now, South Africa's justice system and criminal justice system in particular came into the spotlight this year, leading to various investigations to establish the veracity of Mkhwanazi's claims. But it's not the first time that such claims were made, and former Police Minister Nhlanhla sought to remind the ad hoc committee when he appeared before the parliamentary fact-finding body in October.
General Mkhwanazi is not the first one who made this allegation of this infiltration. if I'm not mistaken, it was said by Judge Tulare here in Western Cape. I think I have.
Yeah, you referred to a judgment.
The judgment.
It's on page 6 of your statement, General.
Yes. Well, the members, I guess they have it, but the judge, this is before Mkhwanazi, where he says, maybe reading that the evidence further shows that the 28 gang and the mobsters in particular are breathing heavily on the necks of the public prosecutors, not only the police. He continues to say, these are prosecutors who guide the investigation of organized crime and institute criminal proceedings against its members. Such prosecutors are under constant and permanent threat to their lives and that of their close families. The evidence also shows that the mobsters have now moved gear upwards and are interfering with the decorum of the courts and the independence of the judicial officers. So this is the judge saying, not Mkhwanazi. So Mkhwanazi is saying this thing much later than the judge has pointed this thing. And testing the judicial oath of office, especially the word without fear.
Meanwhile, one of the people accused of using his influence to play puppet master in the criminal justice system, Vusimuzi Matlala's criminal history yet sweet life, could not be reconciled by members of parliament when he appeared before the inquisitorial body. The alleged drug kingpin and attempted murder accused this year challenged the Alexandra Magistrates Court's decision that denied him bail. His legal team argued that the court misinterpreted the nature of the charges against him. The Johannesburg High Court also denied his bail appeal after hearing arguments from both the state and the defence. Newzroom Afrika's Veronica Mkhwanazi reports.
Vusimuzi Matlala returned to court hoping to overturn a magistrate court ruling that kept him behind bars. The 38-year-old businessman, whose name has surfaced in connection with alleged drug cartels and shady dealings at Tembisa Hospital, stands accused of orchestrating a failed hit on his ex-partner, Teboge Tobejana, an allegation he denies.
The other significant issue that we wish to highlight, my lord, is that there is no direct evidence implicating the appellant in the commission of any of these offences. It's all suspicion and putting together of a so-called puzzle on circumstantial evidence where not all the pieces fit together perfectly.
In September, the Alexandra Magistrate Court refused him bail, finding that he posed both a flight risk and a danger to society. But his lawyer told the High Court that prosecutors wrongly classified the charges as Schedule 6 instead of Schedule 5, unfairly raising the threshold for Matlala to qualify for bail. However, the state prosecutor argued that Matlala's influence and access to resources make him a serious threat to witnesses.
The fact is that the behavior of the appellant is not that impeccable. In fact, he bypassed lawful restrictions of communication from within his cell. What is more, my lord, and that is a point that I've made in my submissions to the Court of Quo also, is that one should have a look at the contacts, the list of contacts that was found on his phone. He had saved a policeman's name as operator, a policeman that is linked to the DPCI.
LaRue also told the court that downloads from Matlala's phone suggest he obtained a fraudulent Eswatini passport, contradicting earlier claim that he had no financial or business ties outside South Africa.
But he then suddenly discloses that fact, which he did not do in his initial affidavit. And it was only upon the fact that he was, I will use the words, caught out, that he's got an interest in a trust entity in Mauritius. It was only then that he disclosed that fact to the court a quo. The importance of this is it shows that the appellant now, has continuously been not forthcoming to the court a quo.
Matlala's defense insists that the state's case is built on weak evidence and speculation. For now, Matlala will remain behind bars. The High Court has reserved judgment in his bail appeal, giving Judge du Plessis more time to weigh the arguments from both sides. For Newzroom Afrika on Channel 405, I'm Veronica Mkhwanazi at the High Court in Johannesburg.
Now, one of the most shocking incidents to emerge from the Nhlanhla Commission of Inquiry was the assassination of Witness D. In response to this, Justice and Constitutional Development Minister Mamoloko Kubai said draft legislation aimed to protect whistleblowers was in its final stages. EMPD officer and now a private security contractor, Marius van der Merwe, was killed at his home in Brakpan in Gauteng's East Rand. Van der Merwe testified before the Commission of Inquiry, investigating allegations of criminal infiltration and political interference in the criminal justice system in October, implicating suspended EMPD Deputy Chief Julius Mkhwanazi in graft within the police service. While police have not yet linked the slain cop's testimony to his murder, Kubai says the Commission will review the manner in which it conducts its work.
It was in 2022 when now retired Chief Justice Raymond Zondo stressed the importance of whistleblower protection in the country's fight against crime. In his capacity as chairperson of the State Capture Commission, Zondo recommended the review of legislation such as the Protected Disclosure Act, and now, 3 years later, it seems work is continuing to realize that ideal.
It's a legislation that is called Protected Disclosure Bill. Protected Disclosure Bill will be the bill that goes into detail and protects our whistleblowers. What this bill seeks to do is to be able to put mechanisms in the country to protect whistleblowers, to be able to link the infrastructure that is currently linked with the witness protection. So that bill has been concluded, is currently going through legal evaluation. We're expecting within the last quarter of this financial year to have concluded this process, and it will be in Cabinet and submitted to Parliament for Parliament to process it.
The parliamentary process will also not be a swift one, and there's been criticism over the slow pace to review the critical piece of legislation as many continue to die. The latest being Marius van der Merwe, a former EMPD officer who fingered corruption-accused Julius Mkhwanazi in disposing of the body of a suspect after severe torture.
I did interact with Advocate Khumalo, who is responsible for the security of the Commission of Inquiry, the Nhlanhla Commission as we know it, did indicate to me that Mr. van der Merwe was offered protection, which he declined because he didn't think that he needed it and because he runs his own security company. We are in agreement that there is a need for us to review how the witnesses are testifying in the Nhlanhla Commission following this incident, and also ensuring that the work is not compromised going forward.
Van der Merwe's tragic death has sent shockwaves across the country, and the Justice Minister firmly believes testimonies in precarious cases should not be publicized.
I do fear for the witnesses, and I'll tell you this why. The reason initially, the proposal that there must be in-camera testification was informed by the fact that there will be risks, and we needed to ensure that the risks are minimized extremely.
2 bullets, 1 life, a family left distraught, and a country awaiting answers. Van der Merwe's death has served as a stark reminder of the urgent need for Parliament and the Executive to act and give effect to the recommendations of the State Capture Commission and the voices of South Africans who suffer in the face of corruption.
Now, in the midst of all these challenges, public confidence in the justice system has taken a significant knock. Today, we examine the criminal justice system from arrest and bail to prosecution and law reform. After the break, we'll take this up with our guest, senior lecturer at the University of KwaZulu-Natal, Dr. Suhaifa Bamji. Stay with us. Public confidence in the system has taken a significant knock. Today we examine the criminal justice system from arrest and bail to prosecution and law reform. I'm joined by senior lecturer at the University of KwaZulu-Natal, Dr. Suhaifa Bamji. Thank you so much for your time, Doctor. Just in relation to the things that we've been looking at, or the various aspects of the criminal justice system that we've been looking at Vusimuzi Kat Matlala, as well as Katiso Katie Molefe, and how they have essentially allegedly managed to maneuver their way in the criminal justice system. When you look at the Matlala case, the bail denials, the allegations of influence and his long criminal history, what does this essentially tell us about power and money and how they interact with the criminal justice system?
Thanks so much. What a great question to start with. So as you said, it's a system. So there's a lot of role players, and we tend to think that the role players in the system are really only the police, the prosecuting authority, and the magistrates and judges. But what we must also remember is that it is about a supply chain or a value chain, if you will. And part of that system are victims, witnesses, complainants. So in totality, we need to look at systemic failures in all of those respects. But if we do bring it down to the question of power and money and influence, then it is about supply and demand. And obviously, well, mathematically, then people who are more well off, for example, can or tend to, in the public eye, have easier rides when it comes to criminal justice.
Doctor, there's also, as you mentioned, that aspect about money essentially being the final arbiter of justice in the criminal justice system, which doesn't bode well for public confidence, as we've mentioned. There's also issues in relation to the review of bail as well as the Criminal Procedures Act. And I think this is an important aspect given the fact that government is trying to ensure that the criminal justice system is a lot more victim-centric as well.
Yeah, so you say that money is the final arbiter. I don't think we'd quite say it's the final arbiter, but it is. It does make significant differences to, well, how we've perceived what justice means for people who are poor and what justice means for people who are well off or wealthy. And then also when you think about what it costs, what lawyers costs to run your own trial, for example, or a defense, it requires a lot of money. So you must have be of means to have an attorney or an advocate that you can afford for. Victims and complainants rely largely on state-provided services. But sometimes we need to think about defenses that not everyone who's been accused is guilty. That's up to be said. So there's much to be said about, the money and the financial issues there. As far as bail is concerned, bail is a touchy one. It's a confusing one for members of the public, certainly, because bail gives the perception that it means that a court has decided that a particular person is not guilty. And that's not the case. And it's a cold comfort for me to say to our viewers that bail is really meant to be a guarantee that the accused person won't skip their trial. I think that's a phrase that many people are familiar with. That it's basically a guarantee or a security that although we are not holding you in prison till the trial date, till the trial actually starts, we're going to let you be out on security, certain amount of money, certain conditions like not being allowed to frequent certain places, not being allowed to contact witnesses, regular reporting at police stations. Now, all of that's fine on paper, but the problem comes about when it's actual implementation of what is happening when someone is in default of a bail condition. So not only not appearing for the trial on the trial date, but all of the other ancillary conditions which go with it.
Doctor, essentially bail, as you correctly mentioned, is enforced or granted by a court to ensure that the appearance of the accused is secured for the next court appearance and throughout the trial. But you look at someone like Vusimuzi Matlala with cases dating back more than 2 decades before Parliament that was read out essentially. How is it possible for someone with such a history to continue operating within the system with apparent impunity? Perhaps if we could take another listen to a bite from Glenys Breitenbach, where she reads out all the charges that have been brought and then dismissed against Vusimuzi Matlala.
Well, in 2000, you were arrested for possession of suspected stolen property. The matter was withdrawn, you'll recall.
In 2000?
Yes.
That's a long time, yes, but I will say yes, yeah.
Yes. Also in 2000, in Silverton, you were arrested for theft out of a motor vehicle. That too was withdrawn. You recall?
I don't recall, but I take it.
Okay. Also in 2000, you were again theft of a motor vehicle in Brooklyn. That too was withdrawn. You recall?
Yes.
Then in 2001, in Cineville, you were arrested for burglary at a residential premises. In fact, you were convicted of that. Is that correct?
Yes.
And what kind of sentence did you get?
4 years.
You served it?
Yes.
2006, cash in transit, you were acquitted?
Yes.
2011, theft of a motor vehicle, it was withdrawn?
Yes.
2012, house robbery, possession of suspected stolen goods, withdrawn?
Yes.
2012, Brooklyn, common assault, withdrawn?
Yes.
2012 in Mamelodi, possession of housebreaking equipment, withdrawn?
Yes.
2013 in Alberton, house robbery, withdrawn?
Yes.
2015, Silverton, carjacking and possession of suspected stolen goods, withdrawn?
Yes.
2016, possession of a firearm without a license, impersonation of a police officer, resisting and obstructing or assaulting a police officer, withdrawn?
Yes.
2018, attempted murder, withdrawn?
Yes.
Now, Dr. Bamji, does this case in particular, in relation to Vusimuzi Matlala, expose weaknesses in the bail regime, or does it point to failures elsewhere within policing, prosecution, or judicial oversight?
Well, look, I'd have to say that looking at, if you weigh up the number of times matters were withdrawn versus the number of times that matters actually were heard, there were only 2. So you look at the case in Senegal, where he was convicted and given 4 years. And then there was a cash in transit one from 2006, where he was acquitted. Acquitted mean not guilty verdict. And the Senegal one, where he was found guilty and given 4 years. But all of the other cases are saying withdrawn. And there's several reasons why a matter or case would be withdrawn. Either there's no prima facie evidence, or there's not sufficient evidence for the prosecution to bring a case, or which links to that is witness withdrawal or loss of docket. So that question about the withdrawals are concerning, and perhaps needs a closer look at to what made those prosecutions be withdrawn or the charges be withdrawn in respect of Mr. Matlala. As far as the bail conditions go, again, look, we know, and you can read very much in the literature and reports of persons who have been accused of crimes are in prison serving time and are still able to run their syndicates and run their organizations very well and freely from prison. But if we're looking specifically in this scenario at the number of, there's only allegations really in the sense because all of these matters were withdrawn. So it's difficult to say that there's a propensity here. We must ask, why were those matters withdrawn? So it's a systemic problem. It's not just about bail. There's no guarantee that if he had been denied bail in any of the other cases and had kept that any of these matters may not have transpired. So that's a very big question mark but it's really for the prosecutorial authorities and the SAPs to explain to us the nature and manner of those withdrawals in all of those several cases.
So we speak about bail as well, and we heard during the Commission of Inquiry that's investigating these allegations of criminal infiltration and political interference in the criminal justice system that there was alleged infiltration, particularly within the justice or the judiciary. Which raises a concern because what the criminal justice system is really is the nucleus of South Africa's constitutional democracy. And without it, there are arguments that everything else would fail. But the allegations that we heard before the Commission of Inquiry was that in relation to bail, the also controversial figure, Katiso KT Molefe, was allegedly granted bail at a price, right? That's an allegation that, of course, still needs to be tested. But a senior member of the judiciary, that is now the acting judge president of the Gauteng division of the High Court, that's Justice Aubrey Lidwaba, accused really of taking this bribe. And there's also a statement that has come from the Office of the Chief Justice, essentially that he would not agree to taking special leave. But when you hear such testimony, that of Witness A before the Commission of Inquiry, and particularly in relation to judicial officers, do we think the problem lies with the law itself or how it was applied, given the fact that even the Constitutional Court, in some instances, has come out strongly against certain judicial officers in the way that the Criminal Procedures Act is interpreted in particular?
Yeah, so again, another good question and also a very difficult one. You know, I think the law that we have on paper is quite adequate in several respects, including our constitution, which is, you know, our firm basis. But we must then also look a little bit more closely at the human beings that are enforcing the law, that are meant to apply the law, and that are meant to implement the law and make it workable in practical situations, like your judges, your magistrates, your police officers, etc. I think this thing about corruption, and it breeds through very many areas of our lives. And I don't think that any particular organization or area or sphere is actually immune to it, unfortunately, but it does come down to individuals. And like I said, it is about supply and demand. I mean, if we just cast our mind back, and this might seem like a little bit off topic, but you'll remember a few days ago, the leakages with the matric exam papers. Now, there again, that's also a form of corruption. That's also potentially criminal offenses there. And it wasn't about magistrates, and it wasn't about judges, and it wasn't about police services. It was about educators and pupils. So it's such a thing where as long as there's a demand for something, someone will be willing to pay for it. So we have to look holistically beyond just the criminal justice system, but also at all of these other social networks and other areas of our lives that are important, where this sort of propensity exhibits. And there's only so much you can say. We need more law about it. We can have a lot of law, but if individuals in the system who it's meant to work for are working counterintuitive or counterproductively to it, no amount of law is actually going to fix that sort of systemic problem.
Thank you. That was Dr. Suhaifa Bamji, Senior Lecturer in Criminal Law at the University of KwaZulu-Natal. Thank you so much, Doctor, for your time. More on the Matlala Commission and its impact on the justice system coming up. Stay with us. Now, the issue of bail, who gets it, who doesn't, and under what circumstances, has emerged as one of the most contentious fault lines in South Africa's criminal justice system. Former Police Minister Bheki Cele bluntly described bail as a mess, echoing concerns raised by police officers, prosecutors and communities who say dangerous suspects routinely walk free, sometimes with deadly consequences.
There are things that frustrate if you work with police. Now, across the justice system, one major problem for the police is something called bail. Well, I'm always told that is a constitutional right. That thing is a mess. That thing called bail is a mess. You know, you go to Tembisa, you find a guy called BP. BP had 43 cash heists and 5 bails. 43 cash heists and 5 bails.
43 cases or 43 alleged?
43
alleged cases.
No, he takes the money. Maybe it's not alleged if he doesn't take your money. But, well, he's arrested now. But he has been arrested and getting bail, arrested and getting bail, and arrested and getting bail. So, police get frustrated with that. One major frustration was a guy called Ntuli, not this one. Ntuli is accused number 5 in the case of
Meyiwa.
Senzo Meyiwa.
Yeah.
Ntuli, as we speak, he's doing 6 life sentences. He was found guilty and sentenced, but got an appeal, or got the right to appeal, and given the bail. When he has been found guilty and sentenced to 6 life sentences, still given the bail. And some of the people that he went after are those that gave evidence against him for him to get life. This is a bail, animal called the bail.
The integrity of the judiciary, long regarded as one of the strongest pillars of South Africa's democracy, also placed under intense scrutiny this year. For the first time in the country's constitutional history, a sitting High Court judge has been criminally charged with corruption. Judge Portia Patlane has described the corruption charges against her as a personal vendetta. The state alleges she received over 2 million rand as a bribe in exchange for a favorable judgment. She appeared alongside her son and the leader of the International Pentecostal Holiness Church, or IPHC, who is a litigant in the matter she is adjudicating. Newzroom Afrika's Linda Mnisi has that story.
The judiciary in the dark, and arguably the first time that a sitting judge is criminally charged for alleged wrongdoing in a matter that they are adjudicating.
A startling plot twist in the civil litigation over the controversial succession battle in the IPHC. Judge Portia Patlane, who has been presiding over the matter since 2013, swinging from the bench to the dock. In her bail application, she says this is a personal vendetta.
That I consider the charges against me as the result of a personal vendetta conducted against me by parties who were involved in a civil dispute with each other relating to the succession battle within a church group called the International Pentecost Holiness Church, the IPHC, after the death of the then leader of the church, one Bishop Leighton Modise.
The state alleges that she received an excess of 2 million rands in exchange of a favorable judgment to one of the leaders of a faction in the IPHC, Nhlanhla, who now lines the dock with Patlane, her son Kagiso, and the spokesperson of the church. In her affidavit, Patlane, who intends on pleading not guilty, says during the trial of the succession battle, she faced threat on her life.
During the course of the said trial, I was personally targeted with allegations against me of corruption and an application for my recusal, which I refused.
The state did not oppose her bail along with her son and the spokesperson. While she was granted 50,000 bail, Her son and Ndala were granted 10,000 rands bail each. But Nhlanhla could not apply for bail due to other outstanding issues that the state needed to investigate. This includes his address and an alleged assault incident that took place during his arrest.
That transpired when the fourth suspect was being detained, wherein the members of the National Intervention Unit were badly assaulted, wherein one of them lost his firearm, but it was later returned by the so-called security that was in the premises, and the suspect was arrested.
Phahlane has also been barred from entering the two Pretoria High Court buildings as investigations continue. This while Judge's matter also calls for her immediate suspension in what it says would be done to protect the integrity of the judiciary.
Judge Phahlane, her son Kagiso and Ndala are expected back in court on the 6th of March 2026. Meanwhile, Begumuzi Nhlanhla's next court appearance will be on the 3rd of December. For Newzroom Afrika on Channel 405, I'm Lean Damnisi at the Specialized Commercial Crimes Court in Pretoria.
The tightrope walked by judicial officers in accountability is a difficult one, but I'm joined in studio by Research and Advocacy Officer at Judge's Matter, Mbigazeli Benjamin. Mbigazeli, thank you so much for your time. Now, it's the first time that we have been confronted with such a matter where a judge, a sitting judge, is facing such criminal charges, or any criminal charges really. That doesn't bode well for the public perception, particularly in such a climate where the judicial system is under such scrutiny.
Greetings, Zalega, and to the viewers. Look, you're quite right. The allegations that we've heard this year surrounding judicial officers generally, but particularly those around Judge Phahlane, do really require some pause, some caution, a little bit of worry. We've never before seen a judge being accused of corruption, especially the difference here is that it's not just allegations on social media, but it is actually criminal charges that have gone as far as the court. Of course, the judge must be presumed innocent until proven guilty, but it is really a deep worry for us that we've reached this point in our country.
And this also happens just a month or 2 months after we heard those allegations in relation to Judge Lidwaba, the now acting Judge President of the Gauteng Division of the High Court. Do you think that what we're seeing unfold at the moment, particularly in light of Judge Phahlane, does it point to a bigger crisis, what could potentially be a bigger crisis in the judiciary?
Well, I think first and foremost, Zolega, we must be cautious in how we approach the two incidents. They are different. The one concerning Judge Phahlane, of course, is different in the sense that there is currently evidence, not evidence, but information on affidavit that is before the courts that includes information such as WhatsApp text messages, information from conveyancers and the like. And so what the police have done, they've done an investigation. They're able to point out a money trail between the accused people, including the judge. And we should draw a distinction between that and the allegations that have been brought against Judge Lidwaba. And there, yes, it is a statement by General Mkhwanazi, who's a senior police officer, and a few other witnesses. But at this point, we don't have substantiation of those allegations. We don't have any information. We certainly don't have any piece of paper at this point that does sort of substantiate those allegations. And so there does need to be a level of substantiation. But what your question is pointing at, Zolega, is that, yes, like all institutions, the judiciary must be under careful scrutiny. It holds enormous power in our society. But at the same time, that scrutiny must be based on facts, on evidence, on substance, right? It is not, and in fact, it is the system at work when we see a judge being taken to task, even when they have done something wrong. So it is something that we should be seeing. It is something that the system it is showing that the system is at work. But it is a concern. I mean, it is not, we've never before had a situation like this where such allegations are brought forward. And so it is worrying about where our systems are going. But at the same time, we must approach it quite cautiously.
And as Judges Matter, you have strongly criticized or called for her suspension. It's also something that has been a concern that has been raised by the Office of the Chief Justice, with the Chief Justice herself saying that these allegations, of course, do not paint the judiciary in a, impugn on the integrity of the judiciary, particularly at such a sensitive time in our country. Do you think also that there must be a faster process in relation to the accountability that we see in terms of judicial officers?
Yes, the accountability systems are far too slow. They don't move at the pace which is required, because the judiciary, unlike other institutions, they don't, like the executive has the police in order to enforce its will. The judiciary only relies on its integrity and reputation and the trust and legitimacy that people have in the judiciary. And so we do need to be able to have confidence that if any allegation is brought forward and is substantiated, that allegation must be investigated and a conclusion should be reached as quickly as possible, not only for the broader integrity of the judiciary, but also to the individual judges who are also, there are allegations that are brought against them, and if there is no certainty or no conclusion around those allegations, they also are living in limbo. But at the same time, Zolega, when we are calling for a swift process, we are saying that the judiciary, like all institutions that have human beings, will have those who don't follow the line, who don't uphold the ethics. And what we are saying is that the system, which is currently the Judicial Service Commission and the subcommittees that operate under the Judicial Service Commission, should have a process that is fair, that is efficient, and that is effective. Currently, the process is not achieving the efficiency that we want. It is taking far too long to deal with complaints. I mean, right now, in January of 2026, it would actually be the 7th anniversary of a complaint that was filed against Judge Nhlanhla Makhubela from the Gauteng High Court. And those kinds of things should not happen. The system should be able to wrap up within a space of a couple of months. And so what we are saying is that there should be a rewriting of the law concerning the complaint system of the judiciary. There should be proper capacitation in terms of staff who are there to adjudicate these complaints. And there should be transparency, because transparency also encourages people to have trust in the system.
When we speak about Nhlanhla Makhubela, Judge Nhlanhla Makhubela, who's been suspended, right, that process is now with the Portfolio Committee on Justice, now looking at an impeachment date to vote, rather, on the impeachment. But that also was, as you correctly mentioned, a process that spanned quite a long period of time. In the case of the Judicial Service Commission Act, as well as the Constitution, they mention various aspects in which, or cases in which a judge can be impeached, right? And those are 3 instances. In the case where we have a sitting judge, right, facing criminal charges, is there room for the JSC to actually maneuver? Because outside of that complaint being actually laid with the JSC, these are cases that are for all to see, where you have a sitting judge facing criminal charges. Is there space there to be made, or for the judge to account in relation to the JSC processes?
Yeah, so maybe let's try and explain what the JSC processes are. So the first and foremost is let me call it the normal route, which is in terms of, you mentioned 3 grounds in which there could be impeachment, which is gross misconduct, gross incompetence, and incapacity. And so let's focus on misconduct, gross misconduct. So the ordinary process is that there is a complaint that is filed on affidavit against a judge, and that is in terms of Section 19(1) of the JSC Act and read with Section 14 of the JSC Act. And that normal route is that after the complaint is filed, it goes to the Deputy Chief Justice, who makes an assessment, and then it goes to the Judicial Conduct Committee, which looks at the information and determines if there's a prima facie case of gross misconduct. If there is, it refers it to the JSC, which appoints a Judicial Conduct Tribunal, and then that tribunal is the one that will hear witnesses and hear testimony, and then make a finding on whether the judge is guilty or not of gross misconduct. So that is the normal process, and as I'm explaining now, it's quite convoluted and quite long. But there is provision in terms of Section 19(1)(b) of the JSC Act, which sort of skips the initial process in the sense that the JSC is given the authority on reasonable grounds. So reasonable grounds are not just an allegation on social media, but a substantive accusation with substantiation, similar to the one right now where a judge is in criminal court. There is an affidavit with information, including WhatsApp messages and other things. The JSC could, based on that information, be able to set up a judicial conduct tribunal and advise the president to suspend the judge. And that is a faster process rather than the normal process. And that is what, in this case, we are saying the JSC should actually use. The JSC should meet urgently, receive the information that is placed before the court, and then take a decision on the suspension of the judge. And that is not only for the protection of the integrity of the judiciary, but also just to give the judge a chance to deal with all of this, because she can't continue to sit in court while all of this is going on.
That's correct. And hopefully the JSC actually does meet soon and resolve this matter with the utmost urgency. That was researcher and advocacy officer at Judges Matter, Mbigazeli Benjamin. Still to come, we will have more on the criminal justice system, as well as those at the helm of the justice system, looking at judicial officers as well, and some of how they have been painted by Nhlanhla Mkhwanazi, the top cop in the province of KwaZulu-Natal. Stay with us. Another day, another tough cross-examination for NPA head Shamila Batoy. This time, Batoy's leadership has come into question. The Nkabinde inquiry is looking into the fitness to hold office of suspended South Gauteng Director of Public Prosecutions, Advocate Andrew Chauke. Justice Bess Nkabinde lashed out at Batoy after she admitted to not reading an email regarding evidence tampering by the Cato Manor Police.
What should we make of that, given the fact that, first of all, the email was addressed to you? Secondly, nothing was done about what appears to have been witness tampering or constituted witness tampering, and nobody did anything about that. My question is, as the head of NPA, what should we make of that, particularly as regards your leadership of the NPA?
Chairperson,
I'm asking this question, Council, and I'm asking it because the buck stops with you in terms of reporting and accounting to Parliament. If this matter were to arise in Parliament, were you going to tell Parliament that this function was delegated to somebody who did not do what he was supposed to have done, particularly when it is clear, as you indicated earlier, that there was witness tampering? Would you have said to Parliament, I do not execute such functions because these kind of matters are normally within the responsibilities of the DPP or somebody, your subordinate, whoever it is?
Yes, I would have, Chairperson.
While the current National Director of Public Prosecutions, Advocate Shamila Batoy, has been facing tough questions at the Nkabinde inquiry, 6 candidates to replace her when she retires in January have faced tough interviews. Advocate Menzi Simelane is the most controversial, as he aims to return to a position he held previously. A Constitutional Court judgment invalidated his appointment to the same position in 2012.
It's been 17 years since the Nhlanhla Commission of Inquiry that looked into Advocate Vusi Pikoli's fitness to hold office during his tenure as National Director of Public Prosecutions raised questions about Advocate Menzi Simelani's integrity as Director General of the Department of Justice and Constitutional Development. The Constitutional Court invalidated his appointment as NDPP by then-President Jacob Zuma in 2010, finding that Zuma failed to consider the Nhlanhla report. But it seems time has done little to change Simelani's view of events. He told the 7-member advisory panel that the findings of the inquiry were not against him.
There are observations made in the report about you having withheld some documents, not cooperated, not being a reliable witness. Those are very specific. Whatever technical term we can use, those were made there. And you would have said, let me challenge that particular aspect in a report because it impugns your own integrity. Would that not be the case?
You're wrong on a number of fronts, Professor Figin. There's no technicalities that was getting into. And I resist your temptation to want to avoid the issue because I want to make these issues that Dr. Nhlanhla raised an issue for you as this panel to think about. So I'm not going to accept your characterization of the issues I want to raise as technical issues. I'm not going to accept that.
But just before Simelane took to the hot seat, former investigating directorate head, who's also vying for the National Director of Public Prosecutions post, told panelists that the capture of the NPA became evident in the same year in which Simelane was appointed.
As the interviews unfolded, it was very clear to me that the purpose was to appoint people loyal to what they considered their faction and not people loyal to what they considered the other faction, which was the Willie Hofmeyr faction. And I remember thinking this is extraordinary because we were appointing people in asset forfeiture. We were developing people in asset forfeiture. It's a very unique skill in the NPA. So there were people who had developed experience and applied themselves, and they were ripe for appointment. They were not recommended in the end over my recommendation.
Cronje also told panelists that Simelane withdrew an application in which a court had granted an interim preservation order during her term with the Asset Forfeiture Unit. Also concerning for panelists was Simelane's admission that he held a meeting as NDPP with the late human rights lawyer advocate George Bizos.
Why particularly you had to call somebody who was familiar with the case coming through from being there to sit in the meeting if the intention was not to deal with the case itself?
No, the gentleman is in the NDPP's office, but I'd asked him to go and speak to the prosecutor at the court about the particular matter to find out.
No, but you are changing your versions.
The panelists are now tasked with deliberating on the suitability of the candidates and will then make a recommendation to President Cyril Ramaphosa. For Newzroom Afrika on Channel 405, I'm Zoleka Kodashe in Pretoria.
From police stations to courtrooms, from bail hearings to commissions of inquiry, South Africa's criminal justice system stands at a crossroads. The choices made in the months ahead, particularly by President Cyril Ramaphosa, may well determine whether justice is restored or further eroded. As Newzroom Afrika will continue unpacking these legal stories and making them make sense for you.